The next case on the call of the docket is agenda number 6, number 125165, People of the State of Illinois versus Kenneth Gaines. Ms. Erin Maureen O'Connell, you may begin.
Good morning. May it please the court and counsel, I'm Assistant Attorney General Erin O'Connell on behalf of the people of the state of Illinois. This court should reinstate the defendant's conviction for domestic battery because his bench trial did not violate the double jeopardy clause. The appellate court erred here in holding that his rejected guilty plea barred the subsequent trial. And the relevant principle for purposes of the double jeopardy clause here is whether the defendant was convicted at the plea hearing such that he could not be re-prosecuted in violation of the Constitution. The record makes clear that the court never accepted or fully accepted or finalized defendant's plea. It never entered a finding of guilty and it never imposed sentence. And in fact, under the double jeopardy clause, under the two-step test of double jeopardy, the court failed to, the claim fails at both steps here. The claim fails first because jeopardy never attached at the hearing. Second, if jeopardy did attach, then it did not terminate improperly, and then defendant's trial was proper under the principle of continuing jeopardy. So I wanted to emphasize here the court, it's clear from the record that the court rejected the plea because defendant never accepted the state's factual basis. It's a very short transcript, and in the space of 2 pages, defendant twice called into question the state's description of the events that occurred, which in this case, the factual basis was that defendant put his hands around the throat of the victim and left visible marks on her throat that were visible to responding authorities. The people gave the factual basis. The court said to defendant, "Do you agree that's what occurred?" And defendant said no. The court said, "Well, do you acknowledge that the state, if it presented its case at trial, would have witnesses to testify that that's what occurred?" And he initially said yes. The court at that point tentatively said that the court accepted the plea as knowing and voluntary. The court turned its attention to sentencing, and then immediately at that point, defendant withdrew his earlier concession. He said that the state could not call witnesses at trial, and that if the witnesses appeared at trial, they would testify to something different. And it was at that moment that the court interjected and rejected defendant's plea. And it plainly had the discretion to do so. A trial court does not need to accept a guilty plea by a defendant who will not concede that he's committed the crime. Here, the court was not required in the first instance to accept the guilty plea. And once it had been tentatively accepted, the court had a discretion when defendant continued to equivocate to withdraw its earlier tentative acceptance and sua sponte vacate the guilty plea. And because the court never finalized the plea by entering a finding of guilt or entering a sentence, there's none of the hallmarks here that Illinois law requires for there to be an actual conviction. And because there was no conviction in this case, double jeopardy did not prohibit the trial, and this court should reinstate the conviction that resulted from the bench trial for
O'Connell, I think that the statute provides, or double jeopardy attaches in other situations where sentencing is not yet imposed. So, for example, a jury is impaneled and sworn, or in a trial before a court with a jury after the first witness was sworn, but before the findings were rendered by the trier of facts. So why should we, in this situation, the judge did say, "I accept the plea," but didn't impose anything. But so why shouldn't we agree with that?
So I would definitely agree with Your Honor that in the trial context, jeopardy attaches at the very start of the trial. Guilty pleas are different though, because there are different policies implicated by the proceedings. So in a trial, the concern is that the state is going to come to bear on the defendant and wear him down through successive proceedings to prove his guilt. So the defendant has an interest in finishing a trial once it is started. The guilty plea context is different because there's no risk here of state overreach. So the principle that's implicated is a defendant's interest in the finality of his conviction. And that interest attaches once there's been a conviction entered. I would argue that the court needs to do something that would create a conviction in this case, such as by finding the defendant to be guilty. The law of Illinois, however, it waits for the sentence to be imposed before a conviction is considered final. So arguably, at that point of the proceedings, that should be when jeopardy attaches. I would note this court in a prior case has held that it doesn't have to reach the sentencing point. And it's consistent with that case for this court to require there to be, at a minimum, a finding of guilt before there are any interests protected by the double jeopardy clause that are implicated.
Counsel, is it your position that the plea was not accepted?
It was not accepted within the meaning of that as a term of art in the guilty plea context. So we would concede that the court used the word accepted, but the context of its remarks makes clear that what it was saying was that it found the plea to be knowing and voluntary. But importantly, even if the jeopardy had attached at that point, at the moment the court used the word accepted, the court still had the discretion from that point forward in the hearing to vacate the plea if something came to light that called into question the defendant's guilt. And that's precisely what happened here. Right after the court said that it accepted the plea based on defendant's representation, that this would be the witness's testimony, defendant then backtracked and said, no, that won't be the testimony. And the court at that point properly vacated the plea if the court were to consider it accepted, such that jeopardy attached.
Thank you.
And if there are no further questions at this point, we would ask this court to reverse that portion of the appellate court's judgment vacating the domestic battery conviction.
Thank you. Miss Amber Lynn Hopkins-Reed.
Good morning, Your Honors, and may it please the court, counsel. My name is Amber Hopkins-Reed, and I'm with the Office of the State Appellate Defender here on behalf of the defendant appellee, Mr. Keith Gaines. This case is about the attachment and termination of jeopardy in a guilty plea proceeding where the court stated on the record that it accepted the plea and then thereafter vacated the plea sua sponte without any good reason to do so. So contrary to the state's first argument that double jeopardy has attached here, jeopardy actually attached to Gaines's plea when the trial court stated that it accepted the plea. A formal finding of guilt or the imposition of a sentence is not required for the attachment of jeopardy. The state here is now asking this court to adopt new magic language in order for jeopardy to attach in a case. The statute, however, already says the language necessary for jeopardy to attach, and that is that the trial court accept the plea. So looking first at the state's argument about the finding of guilt, the state in its brief cites to both Jackson and McCutcheon to support its argument that jeopardy doesn't attach until there's a formal finding of guilt. However, in Jackson, the court first looked at the bench trial and jury trial context and found that it was not necessary for jeopardy to attach in either context. There didn't need to be a guilty finding or not guilty finding entered on the record. The court then immediately went on to highlight that the attachment of jeopardy in guilty pleas to the counts that are being pled to is like its trial counterparts. A formal finding of guilt is not necessary because once the court accepts the plea, there's nothing left to be done in the case. There need only be admonishments, the defendant persist in his plea, and the court accept the plea. In that case, Jackson cites to a case called McCutcheon, where the court notes that jeopardy attaches after the trial court determines that the guilty plea is voluntary and that there's a factual basis for the plea. So under both of these cases, jeopardy has attached in this case because the trial court gave the admonishments, it heard a statement of facts and found it sufficient. As the state even notes, Gaines agreed that the witnesses would testify in accordance with the statement of facts. The court found the plea knowing and voluntary, and then the court stated on the record that it would accept the plea. There was nothing left to be done here. There is a legal inference of guilt, and that is supported by the case law in People versus Dodge. Furthermore,
Counsel, may I ask you this question?
yes,
Of course, there was no objection here. Counsel didn't get involved. Even when it went to trial, there was no issue about double jeopardy raised. So when we look at the record, there's very little record, but perhaps that's because trial court never had an opportunity to develop a record because there was no objection. So here we have another case where there's no objection, and we're going to talk about it plain error. So this is my question. Let's say, and this is a hypothetical now.
okay.
Let's say everything that occurred in this case occurred. Mr. Defendant, you agree with that factual basis, and he says, well, no, but I just want to get this case over with. And the judge said, okay, I'm going to find that you're willingly pleading guilty. I'll accept your plea. And then the defendant says, no, it's wrong. I didn't do this. This is unfair. I'm being railroaded. I don't want to plead guilty. According to your theory, the judge has to go ahead and sentence him. Correct?
No. So under People versus Hankaski, there are several exceptions that the court may use to sua sponte vacate a guilty plea. Specifically, the exception at issue here is whether or not there was a good reason to doubt the truth of the plea. So the analysis would likely fall under that same exception in your hypothetical. So the court would have to make a record that this was a good reason to doubt the truth of the plea. So that might include asking the defendant outright, does he think he's innocent? Does he want to withdraw his plea? Those are things that definitively did not happen here.
And of
Also-
course, again, there was no objection. No one asked the trial court to do that. So at the essence of your argument, are you saying that the plea was terminated improperly, and that there's no explanation as to why the trial court did what it did, and therefore the retrial is barred by double jeopardy? Is that what you're saying?
I'm sorry, can you rephrase the question? I don't.
Right. What I'm trying to get at, you start out by saying that when a plea is rejected, then the issue is whether it was reasonable, whether it was that the proceedings were terminated improperly. Is that what we should be looking at? If in the colloquy right here, where the defendant says one thing, the judge says she accepts, and the defendant says something else, we should be focusing on whether or not the trial court, based on what was in front of her in the moment, terminated the plea hearing improperly. Is that what
Yes.
you're saying?
And had a good reason to do so.
Okay.
So even in a case like People versus Cabrera, the court, since it was going to be, or it was considering whether or not to vacate the plea sua sponte, the court asked the defendant, and there was a colloquy on the record, whether or not the defendant thought he was innocent. And that's where you see the exchange in People versus Cabrera, where the defendant says, I'm innocent. I don't want to be in here fighting this because I can't fight this based on my record. So if the judge is even considering vacating the plea, it needs to meet the exception in Hankaski to meet the standard to be able to vacate. And the state in its brief hasn't clarified a clear standard for this court to use. It seems to suggest that an abuse of discretion standard is necessary. However, looking at several factors, including the language of Hancaski, where it says that there needs to be a good reason to doubt the truth of the plea, this suggests a higher standard than just simply abuse of discretion. This also plays into the reciprocal burden that is on the defendant if he would like to file a motion to withdraw post-plea. Although the standard is an abuse of discretion, the defendant must also show that he's attempting to correct a manifest injustice. This same standard, this higher standard, should apply to the court. The court shouldn't simply be able to unwind the finality of the defendant's guilty plea simply because the defendant is challenging the subpoena powers of the state or stating that the statement of facts given by the assistant state's attorney is different than what maybe the witnesses might testify to, or it's worse, or the optics are different. We don't know, because what the state doesn't highlight is that it filled in the last words of what the defendant is saying. The trial court interrupted, so we're never actually able to know what the defendant was trying to explain. Another reason that there should be a more nuanced standard here is because of the rights that are implicated. As you all know, the double jeopardy rights are implicated here. That's why we're here, but also there's a constitutional right for the defendant to enter into and persist in his guilty plea. And this right is even suggested in Rule 402(d)(2), where if the court followed the proper procedures and wanted to change the disposition in his case, the trial court would have had to ask the defendant if he wants to withdraw or affirm his guilty plea. And
Also,
finally,
are you suggesting then that it is a de novo review? You keep talking about an enhanced standard, should be something higher than abuse of discretion. Are you arguing for a de novo review?
so the standard of review, I think both the state and I have agreed, is de novo review, but at the trial court level, when the trial court is trying to determine whether or not to sua sponte vacate the plea, not just accept or reject prior to the point at which jeopardy has attached, the court should have a somewhat higher standard to promote the finality of the guilty plea, something more akin to clear and convincing, or to correct a manifest injustice, as I said, which is similar to the reciprocal burden that's on the defendant if they were attempting to withdraw in a post-plea motion. However, under either standard, even if this court accepts the abuse of discretion standard by the state that the state suggests, the trial court here did not act reasonably by vacating the guilty plea because it had no good reason to doubt the truth of the plea. Here, there was no claim of innocence. There was no attempt to enter an Alford plea. The defendant agreed with the state that the witnesses would come to court and testify in accordance with the statement of facts. Here, the defendant only challenged the subpoena powers of the state and said that the optics may have been different had the witnesses been able to come to court, but he was interrupted before he could finish and really explain the nuance of what he was trying to say. So,
Counsel, if I could ask you this. The appellate court majority seemed to apply the standard that the defendant must make a clear and unequivocal claim of innocence. Do you agree that that's what the trial judge should be looking for, and anything short of that, the trial judge should not take any action whatsoever?
I would suggest even a clear proclamation of innocence. There may even need to be a higher burden. As I pointed to the reciprocal burden on the defendant, if the defendant were to try and withdraw his guilty plea with only a proclamation of innocence, the fact of the matter is that the court wouldn't allow the defendant to withdraw his guilty plea. They generally request more evidence, even corroborating evidence. So we would suggest that the trial court should also look for corroborating evidence in addition to a clear proclamation that the defendant is innocent or doesn't wish to enter his plea. moving back to the state's argument regarding the attachment of jeopardy and whether sentence is required to impose for jeopardy to attach, the state in its brief asked this court to adopt a bright line rule that jeopardy attaches when the defendant is sentenced. However, there's already a bright line rule. Section 5/3-4 states that jeopardy attaches when a trial court says that it accepts the guilty plea. Accordingly, this court should continue to follow the legislature and 30 years of precedent to find that when the court specifically uses the language in the statute, the intent of the court is clear. The court is allowing jeopardy to attach in accordance with the statute. And the state even concedes in its brief on page 11 that People versus Jackson rejected the argument that sentencing is required for jeopardy to attach in the case. Further, I'd like to address the state's continued use of the word tentative, that this is a tentative plea or a tentative plea acceptance. The state's use of the language is made up, and it's far broader than how it's even used when it cites to 402(d)(2). I think what the state's use of the word tentative really reflects is the trial court here may have been incredulous to accept the plea. Nonetheless, the court followed through and accepted the agreement before it unwound the agreement without following any procedure. If the court was incredulous about accepting the plea, the court could have asked the defendant from the get-go if he wanted to enter the plea, if he thought he was innocent, or the court could have initiated a 402 conference or 402(d)(2) procedures, which we know from the record that the court was familiar with, because the case immediately prior to Gaines, the court issued a 402 conference. So in order to use this tentative language, it would have had to have been at a 402 conference, because even Rule 402(d)(2) states that in order that it has to be done before the tendering of the plea. And the evidence here and the record here shows that this was the formal tendering of the plea. This was not a 402 conference where the plea would have been tentative. Here, there were 402A admonishments. There was a statement of facts. There was even a reference to a written agreement. Then the trial court made a statement mirroring the state's attorney that said that this was the agreement in this case, not a tentative agreement. Further, the court then indicated that it would not participate in any 402 conferences in this case, not any more or another. So we know that this was the formal tendering of the plea, and so 402(d)(2) didn't apply at this point. But if the court had any doubts as to the agreement, it could have initiated these procedures. We also know that 402(d)(2) doesn't apply here because the court threw out the entire guilty plea and not just the sentence. Under 402(d)(2), the court is not empowered to vacate the entire plea. If the court wants to change the disposition on its conditional concurrence with the plea, the court is then allowed to change only the disposition. And when it does so, it has to reaffirm with the defendant that it either agrees and wants to enter into the plea or wants to withdraw the plea. And if that happens, then the court must recuse itself. So we know that 402(d)(2) doesn't apply. So we know from that this was not a tentative plea agreement. This was the formal tendering of the plea. And finally, I'd like to get to the remedy. Gaines would ask that the 3rd District Court be affirmed because his domestic battery conviction was properly vacated by the appellate court because the appellate court could not impose a sentence on a vacated guilty plea, yet it also did not have the authority to reinstate the guilty plea because the plea was not a proceeding that was subsequent to or dependent on the judgment or order in which the appeal was taken. However, if this court finds that the appellate court had the ability to reinstate the guilty plea or should have done so, Gaines requests partial specific performance by reinstating the conviction on his domestic battery count, and this court can either remand for the reimposition of sentence, or this court can find that time has been served because the defendant served a term of 60 months in the Department of Corrections, which is far longer than was negotiated in his plea agreement. If there are no further questions, I would just ask that this court respectfully affirm the decision of the 3rd District Appellate Court.
Thank you, Ms. Reed. Ms. O'Connell?
So I'd like to start by clarifying the standards at issue here. There is a de novo standard on the legal issue of whether jeopardy attached and whether it was improperly terminated. But whether the court properly vacated the plea is subject to an abuse of discretion standard. And defendant, in fact, conceded that in his appellee's brief. One of his arguments is that the court abused its discretion in vacating the plea. So on page 21, he acknowledges that it's an abuse of discretion standard that applies. The heightened standard is not consistent with the briefing, and it doesn't comport with the law in this area. The abuse of discretion standard guides this court in determining whether it was proper to reject the plea at the point in the proceeding before sentencing when the defendant cast doubt on the truth of the plea. And with respect to that issue, we do have a limited record here because the defendant failed to object. The record, I would assert, appears clear enough that the reason for rejecting the plea was his dispute of the factual basis. But to the extent it's subject to multiple interpretations, this court should interpret the record in a way that supports the actions of the trial court and uphold those actions, whereas here there is a reasonable interpretation of the record such that a reasonable judge could construe it in this way and act as this judge did here. With respect to the remedy, if the court agrees that the plea was accepted and defendant was convicted, and then after that, the trial court abused its discretion in vacating the plea, the proper remedy for that error is to reinstate the plea agreement. So in this case, the court would still be reinstating a domestic battery conviction. And in this case, it would be a sentence pursuant to the plea that this court could enter itself. We know that it was a bit of jail time and 2 years of probation. And the state would agree that any sentence imposed here is going to amount to time served because he has already served a lengthier sentence on another count that was vacated below. So in either case, either if the court violated double jeopardy by improperly vacating the plea, or as we've argued, because there was no double jeopardy error and the trial was proper, the result should be the same. The defendant should stand convicted of domestic battery, and this court should reinstate what defendant is saying was this earlier judgment, this conviction that occurred earlier in the proceedings. And the principle as to whether this was subsequent to the appealed order is not relevant here. The argument is that it was an earlier proceeding where the court erred. So the court does have the ability to rectify that error if defendant's argument is meritorious and it was an abuse of discretion here. But we would urge the court to find that there was no abuse of discretion, there was no double jeopardy violation, and thus to reinstate the domestic battery conviction following the trial. And then because there was never a sentence imposed on that, to remand to the circuit court to assess the appropriate sentence on that conviction. If there are no further questions, we would ask that the court reverse the judgment.
Thank you. Case number 125165, People of the State of Illinois versus Keith Gaines, will be taken under advisement as agenda number 6. Thank you, counsel, Ms. O'Connell and Ms. Reed, for your oral arguments this morning.